Yes, of course.
My Lord, I appear with Mr. Bishop for the Transport Action Network. Mr. Flanagan appears for the Secretary of State.
Thank you.
Pursuant to permission from Lord Justice Lewison, this is Pan's appeal against Mr. Justice Kerr's dismissal of its claim for judicial review of the written ministerial statement of the 9th of March, which is in the core bundle at page 228.
Yep.
Which had the effect of reducing the dedicated capital funding for active travel by £200 million, or 2/3, for the last 2 years of the cycling and walking investment strategy period to April 25. My Lord, if I can just indicate where the key papers are. The written ministerial statement is in the core bundle 228, the judgment at core bundle 38, the investment strategy in force at the relevant time is in the supplementary bundle at page 3.
Yeah.
Section 21 is in the authorities bundle, page 22. And Ms. Matthews' witness statement is in the supplementary bundle at page 32.
Thank you.
And those will be the main documents I'll be taking the court to. My Lord, the effect of the decision is that £200 million of the resources specified to be made available in the statutory document under section 21(3) would not now be made available in the period to which it relates. That's the fundamental vice and complaint that we make. And that leads to our ground of appeal in the claim in the core bundle at page 82, where we set out what we say is the error and what we are asking the court to correct. And we say that section 21 prevented the Secretary of State from deciding, other than through the statutory revision process, to not make available resources which had been specified to be made available in the statutory document.
Can you, sorry to interrupt straight away, just through the statutory revision process, and that is the, as far as relevant, the duty to consult people that the Secretary of State considers important to be considered.
Yes, that, but also then to have regard to the desirability of maintaining certainty and stability. That's 21(6).
Yeah.
And then also to see the extent to which the relationship between the objectives and the resources is upset or falls out of kilter.
Right. Okay. Thank you.
And we say that once one interprets section 21 correctly, the decision of the Secretary of State was unlawfully inconsistent with section 21 and with the investment strategy itself. And our headline point, my Lord, is that if the Secretary of State wishes to not make available the resources she specified to be made available, she can revise the strategy under those statutory revision provisions. What she cannot do is have, on the one hand, a SWIS stating 300 million will be made available, and yet make a decision outside that revision framework stating that 200 million of that 300 million won't be made available.
Yeah.
Now, my Lord, the problem is perhaps best illustrated just by the fact that the next day, after this decision, the Secretary of State republished the SWIS to correct a double counting error, and we have no complaint about that, and it's at page 28 of the bundle.
You want us to turn to that?
Well,
the core bundle.
The point is very short. The point is very short that the next day after this announcement, she published a SWIS, a corrected SWIS, which still included in line 1 the 200 million that she had announced the day before would not be made available.
Sorry, this is page 28 of the supplementary.
Supplementary
sorry.
bundle, yes.
Yeah.
So we have a straight inconsistency between the written ministerial statement and the SWIS published the next day. And we appear here, my Lord, because TAN is concerned that the approach of the Secretary of State and the judgment below significantly weakens the statutory framework and is wrong. And as I understand it, on the approach of the Secretary of State, the SWIS becomes simply a statement of intent on day one, on the day it is set, but the Secretary of State retains a generalised discretion unfettered by Section 21 thereafter to adopt an approach inconsistent with it. So whilst our submission will focus on statutory interpretation, the underlying issue is effectively a procedural one.
Yep. And if I summarised it, tell me if I've got this wrong. You say it's procedural because it's how the Secretary of State varies the plans.
Yes, exactly. The strategy. If she wants to vary the strategy, she goes to the statutory variation formula approach. Now, the town has focused on the £200 million issue.
Yeah.
And we're criticised for that because there's obviously other pots involved. The reason we focus on the £200 million issue, because that is the only cut that is known about. And I do just need to make good that point from page 232 of the core bundle. Which is the ministerial submission of the day, on the day of the written ministerial statement, paragraph 10.
Active travel.
Active travel,
yeah.
And we don't. There you see the 65%, which is the basis of the 200 million point, and the difficult to justify because of high value for money and so on. But the key words are these: we are working through the implications of this as other travel funding, as other active travel funding may also be reduced. And what that means is that because other pots elsewhere, which are not ring-fenced, may be being impacted by other cuts elsewhere, there might be knock-on consequences on the proportion of those pots available for active travel. But it's not defined, and we can't get at what that figure might be. And hence we're focusing on the £200 million cut.
Which raises this point for you to address as and when is convenient. From the respondent's argument, they say, well, this is all really a generality and aspirational, and whether or not they complied with Section 21 properly in the first place, neither here nor there, because you're not challenging their failure to bring a scheme into force at all. But actually, when you look at it, it's all nebulous and doesn't really exist.
Yes.
And at some stage, whenever it's convenient, if you can give us the detail to either show that's right or wrong.
Absolutely, and I'll be showing my lord why it's wrong for all the lines, but it's very specifically wrong for line 1.
Thank you.
So what I'm going to do, if it subject to the court's indication to the contrary, I was going to start by concentrating on the correct interpretation of Section 21, having regard to its statutory purpose. And going through that, I'll pick up most of the points raised in the judgment and my own friend's submissions.
Yep.
I'll then try to consider the facts and show the inconsistency with the SWIS itself, at which point I'll build in the answer to my Lord's question as to the estimate point. And then I'll try to address any other matters outstanding that I haven't been addressed by then.
Thank you very much.
Now, my Lord will have seen Section 21, and I'm not proposing to read it. I'll come to it in detail in a few moments. But of course, statutory interpretation requires one to give the words used their natural and ordinary meaning in their context, including the statutory purpose. And so I'm going to start with the statutory purpose. And for this, if we can have my skeleton and Miss Matthews, my skeleton at paragraph 15 and Miss Matthews' witness statement open, please. Where she...
and where is she?
That's at supplementary bundle, page 33.
Thank you.
And it's paragraph 9, which is where I get my key words from in my skeleton. And we accept and endorse what she says here. Prior to 2015, funding for cycling and walking had generally been somewhat ad hoc and piecemeal, with no clear long-term strategy. This changed with the coming into force of Section 21. And over the page at paragraph 12, you'll see a quote from the first SWIS, and at the bottom of the first quoted paragraph, 5.2.
Sorry, where are you now?
Paragraph 12, but within that paragraph 5.2, the italicised. The part of the purpose was to reduce the potentially negative impact of the stop-start funding. And that's all about just having some money one year, not much the next, local authorities not being able to plan how they roll out.
How does a strategy made after the enactment enable us to interpret the statute? I mean, I well understand it's a helpful comment from your point of view, but if we're looking at what we can take into account in interpretation,
I'm very happy to go back to the words ad hoc and piecemeal.
Yeah, no, that I understand from the comments from the witness statement, as it were, but a strategy made pursuant to a statute may be right, may be wrong.
I accept my lord's point. But the piecemeal and ad hoc nature of it gives rise to the stop-start. But all of that arose under a generalised and unconstrained resource allocation discretion.
Yeah.
And that's the discretion my learned friend refers to, in which my learned friend says has survived. And we say it hasn't survived, for reasons I'm going to come to. Now that was the problem that Parliament faced, and it decided that situation was unsatisfactory, and therefore the intention of Parliament in enacting Section 21 was to move away from that. And of course that we know the Quinterval proposition is well known. It's in the bundle. It's in the core bundle at page 119 if you need it. But perhaps I should just turn that up.
Core bundle 119.
Core bundle. Apologies, I've just managed to lose my place. Apologies. Core bundle 119. This is the my skeleton, I think, below. Below.
Yeah.
In passing legislation, Parliament always intends to make some change or address some problem or remove some blemish to effect some improvement in national life. That's what it was doing here. It was trying to change or remove the problem or cure the problem. And it did that, the mere existence of Section 21, but the words used in it, it did that by replacing and excluding the ad hoc and piecemeal approach under the unconstrained and generalised funding discretion, the prerogative power effectively, and it replaced that with a statutory scheme for the investment, requiring an investment strategy to be set, specifying the objectives to be achieved and the resources to be made available. I'll come to the precise wording in a moment. With powers to vary that through the statutory process, all the while having regard to the desirability of certainty and stability. And those are statutory words for avoiding stop-go. And in my respectful submission, the key, at the heart of this case, the key point is this, that the purpose, or at least part of the purpose, was to remove the unconstrained discretion so as to avoid its unacceptable effects and to create a more settled regime. My lone friend focuses on the Secretary of State's freedom in respect of resource allocation decisions and the light touch to such resource allocation decisions. TAN has no argument with those principles. I'll come back to the detail later on. But here, Parliament has constrained the Secretary of State's freedom through Section 21. And it has set a framework for the allocation of resources to replace or to be read where the Secretary of State's freedom is subject to. And, my Lord, all we're asking is for the court to require the Secretary of State to do that which Parliament required. Now, with that in mind, my Lord, I was going to come to section 21, and I'm going to try to make 10 points which pull together everything from my submissions, the judgment, and Mullin's defence, and I hope that's convenient. And if the court could have section 21 open, that would also assist. The first point is that section 21 provides a self-contained statutory scheme replacing the former discretion with a comprehensive statutory framework. It's all there. Everything for the investment strategy is in section 21. Second, the combined effect of section 21.1 and 21.9 is that an investment strategy will be set. If there isn't one, the Secretary of State has to explain why not and has to provide one as soon as reasonably practicable. And so the investment strategy is the statutory vehicle for achieving the statutory purpose.
I mean, time has passed. Are we still on the same strategy?
No, it ran out a few weeks ago, in April, and the next one hasn't yet been published because the Secretary of State has told Parliament that she's waiting for the spending review, which I'm not sure when the spending review is, but so she's given an excuse to Parliament, and she'll adopt a SWIS presumably as soon as reasonably practical after the spending review.
That raises issues about relief, if you're right, which you'll no doubt address as and when it's convenient.
Yes, of course. Of course, but in the light of the current circumstances, we're not asking the decision to be quashed. We'll be asking for a declaration.
Yeah.
When the judgment occurred, there was some merit in seeking a quashing. But
no, we understand that, but that's why I just wanted to clarify the current situation.
Yes,
so if you're right, you seek only a declaration.
Effectively, in the terms of the grounds of appeal.
Yeah. Yep.
Can I then, this is still under the second point. The word set is important here because it means fixed or decided or determined. This is in section 21.1. And it's set until varied under 21.1b or until reviewed under 21.2 or until the SWIS expires. Third point is that a consequence of that statutory framework is that there will continually be a SWIS, or the Secretary of State will be working towards one. So the point I make from that is there's a comprehensive temporal ousting of the generalised discretion. Once there's a SWIS, you're in the SWIS, you're not in a generalised discretion. I'll come to the discretion in setting the SWIS in a moment, but once you're in one, you're out with the generalised discretion. The fourth point is that an investment strategy for England is, by definition, a high-level strategy. And for that, I would like to take up, please, Lord Justice Holgate's judgment in the first TAN case, TAN 1 I call it, which is in the authorities bundle. This concerned a challenge to the road investment strategy.
Yeah. Page.
Well, if we go straight to the bit that it's paragraph 37, please, which is at page 230 of the bundle.
230.
230.
And paragraph 30.
37.
37. Thank you.
This is consistent with the high-level nature of the RIS as a strategy for public investment. That's the whole point. of it. It is a high-level strategy. And my Lord, I need to do a little bit of a diversion here because of the way the judge and my learned friend approached this. Because somehow there's criticism for the fact there's not a costed schedule of works or a costed scheme of projects, but that's in the nature of the beast. And given the subject matter, which are, as I'll show my Lord when we get to the Swiss in due course, predominantly relatively small-scale schemes in cities, towns and villages across the country that are bid for and delivered by local authorities. And therefore it's obvious that the Swiss is not required and could not be expected to identify specific projects. And I say that's simply not its role. The identification of the specific projects is for the bidding process and the award process by Active Travel England further down the line. The fifth point, and of course we need to read each word carefully as well as the whole, the term strategy is the polar opposite of ad hoc and piecemeal or some generalised discretion.
There's no statutory definition.
No statutory definition. I'll be corrected if I'm wrong, but no statutory definition. But just the use of the word strategy is the opposite of ad hoc. Sixth, the Swiss under section 21(2.
Sorry, do you mind if I just ask you a question on that? Of course, no. Why do you say a strategy is the antithesis of ad hoc and piecemeal? I mean, lots of strategies are pretty hopeless and change day to day.
Well, the statutory scheme here requires a statutory for period. I'm coming to the period next. That's the first point. The second is it's a high-level strategy for England to set the strategy for the country.
So in context.
In context, yes.
Right. Okay. Thank you. But not just strategy itself.
The word
because you were concentrating on the word strategy.
Yeah, the strategy in its context here means the opposite of, and I say the polar opposite of an ad hoc and piecemeal approach.
Thank you. Sorry to interrupt.
And I may push that a little bit further, actually, my Lord. Even the word strategy has connotations of a plan that isn't going to be blown around by the vagaries of day-to-day pressures.
Perhaps should do.
Perhaps it should do. Maybe that's counsel of perfection. Sixth, and this is a key point which I haven't developed sufficiently in the skeleton, and I apologise for that. It's 21(2). Section 21(2). One has to, the strategy has to set the period, has to define the period by reference to which it is set. So a cycling and walking investment strategy is to relate to such period as the Secretary of State considers appropriate. But a strategy for a period more than 5 years must be reviewed at least once every 5 years. At risk of stating the obvious, the Swiss is then the investment strategy for England for the whole of that period, by definition, unless and until it's varied. It's not, as the judgment and my own friend would have it, just a snapshot of intent at the outset. Seventh, we know from section 21(2) that period can be more than 5 years. But in my submission, with the use of that terminology, 5 years, it's clear that Parliament had in mind the Swiss being relatively long-term. Again, the polar opposite of ad hoc and piecemeal. And I say, consistent with Lord Justice Holgate's judgment in Tan 1, that is in any event embodied in the word investment strategy. It's a high-level strategy for the period, and things can change under it. I'll come back through the variation process, but it's for the period to which it relates. The eighth point is my longest point, and it has to be broken down into a number of sub-points, and this is 21.3. And I'm going to deal with this under three subheadings. First of all, the introductory words, then 1A, and then 1B. So the cycling and walking investment strategy, which is set under 1, must specify the matters then set out. So that's a mandatory formulation to deliver the statutory purpose. Now, in setting and specifying, it's important to recognise the extent of, or the unfettered extent of the Secretary of State's discretion at that stage. Right at the outset, before she sets the SWIS, before she sets the objectives and the resources, she has a very broad discretion as to what objectives to set and what resources to be made available for the purpose of meeting those objectives. It's entirely up to her.
Is there a duty to consult before the strategy is set out?
Not before it's set out, but before actually setting it, she has to consult on it with such people as she deems appropriate. If you look at subsection 21.5.
Before setting it, yeah.
She doesn't ask people what it should say before she comes up with it. She comes up with it and then and consults on it.
And do we know who were consulted before the SWIS? You'll tell us that when we go through the.
Yes, I can't help you precisely. It is in the paper somewhere, maybe in Miss Matthews' statement, but it wasn't TAN.
No.
Is that right? There is a sentence somewhere, but I can't immediately put my finger on it. I'm afraid. Paragraph 23 of Miss Matthews' witness statement tells you.
Which was?
This page 36 of the supplementary bundle, paragraph 23. This is for SWIS 2. The DFT undertook a process of targeted consultation in June 21 to February 22. This included workshops with key active travel stakeholders, as well as with a range of other stakeholders, including local authority transport and public health officials, disability organisations, and the private sector. So there was extensive consultation there. This is in informing her as to what to set for the objectives and what to set for the resources.
Yeah.
So those matters, what to put in the SWIS, are matters left by Parliament to her. And we know that, for example, she does the consultation and she takes expert advice to ensure the objectives and the resources are related one to the other. And the advice here, the relevant advice, we don't need to go to it, but there's a document in the supplementary bundle, page 104, which is an CWIS insights paper that shows how the correlation between objectives and resources, two sides of the same coin, is worked out. So she has this this unfettered resource allocation discretion at the outset as to the priorities and objectives. And she may, the judge said, those objectives could be vague. Well, they can be generalised and they can be not particularised by reference to a particular percentage improvement or anything. Of course they can be. That's up to her. She may be ambitious or less ambitious. She may be invest heavily or not invest heavily. That's up to her. But all of that is before she sets the SWIS. So that's my first subpoint under this heading. The second subpoint is 21.3a. And the words, objectives to be achieved during the period to which it relates. So the objectives are specified for that period. And in my respectful submission, it follows inevitably from that formulation that they remain specified for that period throughout that period. That's the whole point. They are the objectives for the life of the SWIS, unless varied, of course. Thus, we know that the objectives are not just a snapshot in time. They're not just a statement of intent at the beginning. They remain the objectives throughout. And that, in that sense, they're temporally continuous through the life of the SWIS, and the SWIS is continually speaking as to those objectives. I need to just have a slight departure from the chain of logic here to deal with a duty to achieve the objectives. Can I make it quite clear that for the purposes of my submissions here, and on this challenge, TAN does not contend, and does not need to contend, that there's an actionable duty on the Secretary of State to achieve those objectives. That's not part of our case. And my Lord Justice Holgate, in the first TAN case at 121 and 126, probably necessary to turn this up.
121.
Sorry, this paragraph number is 121, so
Oh, right,
I apologise. So it's page 252 and 253.
Yeah.
Right at 121, a road investment strategy is set in order to provide the framework for the relationship between the Secretary of State for Transport and the Strategic Highway Company. It does so by laying down the objectives to be achieved by the company and financial resources that the government will provide. And then over the page, at 126, there's emphasis laying on the Section 3.6 duty, as I'll come to later. But the Secretary of State for Transport and Highways England have to comply with RIS 2. But that's a requirement of a general nature addressed to a strategy as a whole. It promotes the delivery of the projects identified, but it does not create an absolute obligation that each project must be carried out. The strategy may be varied under the variation provisions, of course. And then at the bottom, a scheme will only remain in the strategy if public investment is justified. Again, because there's the provision within the RIS for investment decisions to be reconsidered on individual schemes. Yep. So I'm not saying there's an absolute duty on the Secretary of State to achieve the objectives, or even an absolute duty to make sure that every penny of the dedicated funding is actually spent.
You started your submission by referring to a duty. You've now referred to an absolute duty. Are you intending to make a distinction?
No, I wasn't.
No.
I apologise.
I just wanted to check. Sorry.
I'm hopefully being. I'm trying to address in advance the AA point with the distinction between target and absolute. It doesn't go anywhere on the facts of this case because our case is not that there's an absolute or even our case is not that there's an absolute duty, that an actionable absolute duty that this has to be delivered, or that there's an actionable duty at all that this that she has to achieve the objectives.
That seems to be qualifying what you said in your skeleton at paragraph 43.
Yes, there's one
page 13 of the core bundle.
Yes, paragraph 43.
I think so. Maybe I've misread it.
No, there is a bit where I've used
language which sounds a bit actionable.
I apologise, my lord. Which paragraph?
43.
On page 13 of the core bundle. Internal pagination
yes.
11.
In the previous paragraph, I've said no target or absolute duty. And I've said if necessary, to the extent necessary to sustain the appeal, and I'm not pursuing that.
But you don't need the point.
I don't need the point.
But to make a procedural submission.
That's exactly. Yes.
But nonetheless, 43 was being a bit adventurous.
Well, it might have been being a bit adventurous, but also, yeah, and I don't need it, and it doesn't go to my essential chain of logic. In a different case, if there'd been a wholesale failure to achieve the objectives, or if the report to Parliament said we were so off track on achieving the objectives,
if it's a different case,
it's a different case.
Leave it for a different day.
Thank you. Can I then please move on to section 21.3b, which is obviously
Of course,
where this...
that's your third part of
yes.
your 8th point.
Exactly.
Yeah.
And I'm afraid this part is then also in some subparts.
Right.
First, just look at the words. And as I say in my skeleton, the words specify resources to be made available are clear and ambiguous and require no elaboration. And the fundamental point here is this, that those words mean that the SWIS is required to embody the resource allocation decision of the executive for the period to which it relates. So she's required to set out in this document the resources to be made available. She's got a freestanding discretion at the outset to decide what resources to be made available and what the objectives are going to be, but she's got to put them into this document, and when she does so, that is the executive's resource allocation decision. Which Parliament has told her she has to do at this point, at the point of setting the SWIS. That's my first headline and overarching point. The second point is that the objectives in A and the resources in B are the two sides of the same coin. And we know that because the words for the purpose of meeting those objectives. They're a package, with each reflecting the other, and with the resources being set consistent with the objectives and vice versa. You have to, it's set as a package. I want to achieve this, this is how much it costs, or I've got this much money, these are the objectives I can achieve. And the two are two sides of the same coin. Third point, the period, therefore, must be the same period to which the SWIS relates. And so again, not a snapshot in time at the outset. It must be the financial resources to be made available by the Secretary of State for the purposes of achieving those objectives in the period. And the fourth subpoint here is that to be made available is necessarily different from being spent. And that's a function of the nature of the subject matter. If we can please go in the supplementary bundle to page 212, we see how this actually works out with the dedicated capital funding. We can see how this works out in practice. Page 212 of the supplementary bundle.
And what are we looking at here?
This is an announcement of 200 million of the dedicated capital funding. And the position here is that on the 6th of February 23, the Secretary of State had made available 200 million, as she'd said in the SWIS she would. And she made it available to Active England, and we can see over the page at 213, the second main paragraph, Active Travel England is today inviting local authorities in England to apply for funding to make improvements to enable people to choose active travel, which can then help them save money and stay healthy. And then we see creating more paths in rural areas, safer routes to school, improved safety at junctions for people walking and cycling. So it's a big pot of money made available by the Secretary of State to Active Travel England, who invite bids and then allocate according to their criteria, their investment criteria, to local authorities for the local authorities to get the spades in the ground. And it's inevitable in that context that the precise allocation to specific schemes is further down the pyramid. It's not in the SWIS. It's way further down the process. Now going back to my 10 points, and I'm now on the 9th point, I hope.
Yep.
There are statutory variation provisions and restrictions. And if I can just take, I think I've already adequately introduced them, but if we go to 21(1)(b), the Secretary of State may at any time vary. So she can do it at any time she wishes, but that is subject to 5 before varying. The Secretary of State must consult such people as she considers appropriate. And then over the page, 6, in considering whether to vary, the Secretary of State must have regard to the desirability of maintaining certainty and stability in respect of SWISs. In other words, a purpose of the SWIS is certainty and stability, and in varying them, she's got to try to maintain that certainty and stability, or at least have regard to the desirability of maintaining that certainty and stability. And whilst we're on the variation, of course, if there's a substantial change in the resources to be made available, the variation may also have to revisit the other side of the coin, namely the objectives. So in deciding whether to make a cut, the Secretary of State will have to address her mind to whether the cuts that would be necessary and the loss of value for money schemes, very high value for money schemes, is justified. So you'll have to think about the pros and the cons of the cut. You can't just look at the I need to save some money side of it, because it will have the knock-on consequences of the objective. So it's a package, it all comes together. She can vary at any time, she has to consult, she has to think about stability, but she has to think through the consequence of the variation.
The consequences may be the speed with which you deliver generalised objectives.
Yes, it might be, and you could easily defer.
You could defer by a year or two.
You could easily say that. You could easily say, I'm going to make a decision now that the SWIS is going to be extended, and she could say that in a variation. She could, and that would be one answer to the conundrum that she faced, that she could have consulted on a variation. But I'll come to the conundrum when I get to the facts in a moment.
Would a variation extension, so you've got a 5-year period, suppose you set 5 years,
yes,
so that you don't need to carry out a review, and then 3 years into it you set your variation under 21, 5 and 6. Would you then need to do a review after the original 5 years?
Such period, so it will be to such period as she thinks appropriate. So that will be originally 5 years, but then it will have been
Extended in the variation by a year.
Well, yes, but effectively that is the varied SWIS. I hadn't thought of how that would work out.
It's not an issue on the appeal, but if we're looking at in the interpretation,
yes,
sometimes it was useful just to look at some of the edges.
Yes, it would be. I can't immediately answer my Lord's question on that. And if I can,
sorry to have asked it.
if I can have a bit of time.
Of course, yeah.
Well, a variation may not amount to a complete review of the strategy.
No, it might not. It might be isolated, and it might be possible to isolate it, but she has to think about whether.
But if you don't do a review, I think my Lord's question is, nonetheless, there is a requirement to review at least once every 5 years.
Yes. So if you haven't done a variation, you either get a new SWIS after the 5 years because they're aligned to the spending review periods, or you review your longer term SWIS. And the 10th and final point is that the Secretary of State is required to report to Parliament from time to time. 21(8). And that is a report on the progress towards meeting the objectives. Now, in my respectful submission, that's in addition to and not a substitution for the other provisions of section 21. So it's not saying, don't worry about everything above, you just have to do a report to Parliament. It's therefore no answer to this challenge to say that a breach of 21.3 is somehow policed by 21.8. I therefore return to the headline point that once a SWIS is made, the Secretary of State's role, refinancing, is to make those resources available and is not to decide not to make those resources available. Now, my Lord, the court, the judgment and my learned friend refer to section 3, which is the RIS obligation, and the lack of a duty in section 3.6, an equivalent duty of section 3.6 in section 21. I can deal with that now, or wait to hear what my learned friend says. I'm in the court's hands.
Well, I'd make your submissions while you can.
Right. Well, okay. In that case, my Lord, the first point is I repeat what I say about duty. Our case is not dependent on the duty. That's the fundamental starting point. If we go, though, please, to RIS section 3.
And I was looking at the thing. So where is it in the authorities?
The authorities bundle, page 20.
Thank you very much.
But also we'll need to go to page 24, which is the way the RIS is set.
Yeah.
So, and I'm going to show my Lord that the RIS context and the statutory framework is markedly different. So, if we start with Schedule 2, this is how the RIS is set. And we'll see an iterative process between the Secretary of State and the Strategic Highway Company, here Highways England. And the first that we see, you can see the Schedule 2, paragraph 1.1. This part specifies the procedure by reference to which the RIS is set. And then at 2.2, the process is as follows. First of all, the Secretary of State provides proposals to the SHC, to the Highways Company. And we can then see and those must include the objectives to be achieved by the company and the financial resources to be provided by the Secretary of State. So again, two sides of the same coin, different parties on the different sides.
Is there any point to be made about the fact that this refers to be provided by the Secretary of State as opposed to be made available?
I haven't made a point about that at the moment, but this is, as I'm going to come to in a moment, my Lord, this is effectively a statutory agreement between the SHC and the Secretary of State. On the one hand, the Secretary of State sets out what she wants to achieve and says this is how much money I'm going to provide to you for achieving the objectives I'm setting for you.
So the provision of the resources by the Secretary of State might be a correlative of imposing an obligation on whatever they're called, Highways England, to comply with the strategy.
Yes. And
which is more project specific.
Yes. Yeah. First, much more project specific, as my Lord's TAN 1 case was about the 50 specific major highways project on the strategic road network.
Yeah.
Not hundreds of little schemes around the country. So yes, I adopt my Lord's observation there. But we then go to Schedule 2, paragraph 3. Sorry, Schedule 2, paragraph 2.3, which provides for the company to respond. And then we see the response over the page at paragraph 3. It can either agree or make counter-proposals. So the company can say either what you're suggesting as the resources isn't adequate, or the objectives are too difficult, or we can't do it in the timeline, or whatever. And this is an iterative process, because then after that, if we see it paragraph 4 that if the company agrees, then the Secretary of State may publish. But over the page 5, if the company has made counter proposals, then the Secretary of State has a range of options. She can either plough on with the company's with her original proposals, all the company's counter proposals, or provide revised proposals, and we go around in a circle again if there's revised proposals. And so that's what I mean by the iterative process. And if we go then back to section 3...
And just before you leave Schedule 2, in paragraph 6, that's where Parliament has put in subparagraph 3, having regard to the desirability of maintaining certainty and stability.
Yes, so
that objective appears in Schedule 2 as well.
Yes, in the same way as it does in section 21, 7, 6, or 7, 6.
Yeah.
And this provision for variation is a lot more detailed and complicated.
A lot more detailed and complicated.
Than the process for revising the cycling strategy.
Because it's an iterative process between...
Yes, you've got to repeat, you've got to go back to square one and do it all again.
Yes. But we can see how that plays out in section 3 itself, my lady. If the court could turn to page 20 of the authorities bundle. This isn't the Secretary of State setting a RIS for herself. She sets the RIS for the highway company. So it's
she is setting it in part for herself because her part of the deal is she has to provide the resources.
Oh yes, but the word, could I just ask the court to look at 3.1a? Sets a road investment strategy for a strategic highway company. And I come to 3.3 in a second. And she can then vary it, and my lady has referred to Schedule 2, paragraph 6. And then,
I mean, but you've got subsection 6 as well. Both the company and the Secretary of State must comply.
I'm going to come. Yes. So, but we see in 3.3 that it must specify the objectives to be achieved by the company and the resources to be provided by the Secretary of State. So that's what I've termed the package arrangement between two parties, two sides of the same coin, but between different parties. And then we get to...
presumably provided is used rather than made available because the strategy is effectively between two parties, so you know who you're providing the resources to.
Yeah, you know exactly who you're providing.
Whereas with the Section 21 strategy, you don't know who you're going to be providing the resources to.
No, you have this arm's length body called Active Travel England, who is given the powers, given the role of distributing the money, of having an investment strategy for itself and deciding what the priorities are and where and how to score bids.
Right.
But that's a allocation of the resources that have been given to them by the Secretary of State, not the prior question.
But in addition, if you're going to have a statutory scheme for the strategic road network, which imposes a statutory obligation on an arm's length company to comply with a project-led strategy, to be able to comply with that duty, the Secretary of State needs to provide the resources.
Yes, and that's exactly why, and that in my respectful submission is why subsection 6 is there. The Secretary of State and the company must comply with the road investment strategy.
Yeah, exactly.
Yeah, and my lord, in TAN 1, paragraph 126, is perhaps we should...
Because before this came along, there was an agency, an executive agency, which was part of the Department of Transport.
Yes.
I've forgotten what it was called. It's dealt with in TAN 1. But this is setting up an arm's length company.
It is. Yes.
So when you split the functions in that way, you need these statutory duties.
Yes, and that was going to be my ultimate point. It's a function of the nature of the arrangement between two parties, two separate parties, that you need to have this duty imposed. That's between two of them. And therefore, in my respectful submission, the section 3.6 point, even if I was arguing for a duty, an actionable duty doesn't assist. but I'm not. I'm talking about the application section 21.3.
You mentioned a couple of times Active Travel England. Is that a statutory body? Do we have any details of how that's set up, or is it covered in the Infrastructure Act?
It wasn't set up in the Infrastructure Act, but again, I think it's dealt with in Miss Matthews' witness statement, but I can't immediately put my finger on it. I don't see that. Paragraph 26, thank you so much.
Which is page?
Page 37 of the supplementary bundle.
Thank you.
Sorry, paragraph
26. Page 36 and over the page.
Thank you.
So no indication there. I don't think that it was a statutory establishment. It was just within the department.
The government executive agency.
Yes.
Yeah.
But my lord will have seen the reference I gave earlier to the 200 million that was effectively given to it to allocate at page 213. So its role is to invite bids, determine the bids, and pay the money over to the local authorities who win. So that brings me to the end of my submissions on the correct interpretation, and I now go to the consequences of that interpretation, if I may. And I'm going to pick this up, if I may, from my skeleton at 44. And I accept, of course, that these submissions only work if my interpretation is right. And I'm going to read and take my lord's, the court, to the cases as we go.
Yep.
First, and this is a point of general principle, where Parliament has imposed on the Secretary of State a duty to do a particular act in a particular way or through a particular framework, that act can only be done thereafter under that scheme, and the Secretary of State cannot act inconsistently with or outside it. Now, my own friend in his skeleton, paragraph 33, refers to it as Lord Justice Carnworth's inconsistency principle. I go to but Lord Justice Carnworth, in the case that my own friend relies on, refers to the House of Lords in the Fire Brigades Union case, which, as far as I'm aware, is still the leading authority on this for that proposition that I've made. So I was going to take it up with the Fire Brigades Union case. Now, this was a situation where the criminal, there was a criminal injuries compensation scheme, which was obviously of significant interest to fire personnel, and the legislation was going to introduce a new scheme whereby the compensation was assessed by reference to the principles of tort. So that legislation, as my lord will see from the Fire Brigades Union case at page 46 of the bundle, of the authorities bundle, that legislation provided that it would be brought into force by order of the Secretary of State. But instead of bringing it into force, the Secretary of State decided to adopt a non-statutory tariff scheme, whereby effectively he said, for a broken leg you get this, for a burnt arm you get that. So rather than the principles are applicable to tort. And the Fire Brigades Union challenged on the basis of the failure to continue the inconsistency between that and the obligation to continually consider bringing in the statutory scheme into force. So I accept it's not on the same facts as here, but the principles are of general application. And if I can take the court, please, to Lord Brown Wilkinson at page 551, just above the letter C. and this is about whether to bring the legislation into force. It cannot have been the intention of Parliament to leave it in the entire discretion of the Secretary of State whether or not to effect such important changes to the criminal...
Sorry, where in the authorities bundle?
Apologies, my Lord. Tab 4, page 84.
84. I went to page 551 as requested, and it's only 84 pages long.
Apologies.
Internal pagination 551.
Yeah. Thank you, yeah.
Above letter C, this is just a comment on the duty to consider to bringing the legislation into force. It cannot have been the intention of Parliament to leave it in the entire discretion of the Secretary of State whether or not to effect such important changes to the criminal law. In the absence of express provisions to the contrary, the plain intention of Parliament in conferring on the Secretary of State the power to bring certain sections into force is that such power is to be exercised so as to bring those sections into force when it is appropriate, and unless there's a subsequent change of circumstances which would render it inappropriate.
But this is dealing with a situation where the Secretary of State supposedly doesn't make a Swiss at all, and then purports to just act in a discretionary manner.
Entirely discretionary manner, potentially, yes.
Whereas, as I understand it, your case is the Secretary of State did produce a strategy.
Yes, but the point of principle is the consequences. If my interpretation is right, what does that mean for the Secretary of State's ability to act outside the Swiss?
In terms of a variation?
In terms of a non-statutory variation?
Yes.
In terms of not doing what the Swiss says, is she allowed to, on the one hand, have a statutory document that says X, and on the other hand, to have a decision outside the statutory?
It might be just easier to say, if you've set up a Swiss, then you have to comply with it under Section 21, rather than anyway.
Yeah,
you argue it how you choose.
Take, for example, a review. Your argument is you couldn't carry out a non-statutory review of the whole strategy. You would have to do it under the statute.
Yes, the 5-year
review.
So
you say by parity of reasoning, the same applies to a variation.
Yes, yes. And
if it's a variation.
A variation, there's a statutory variation procedure, you do it under the statute. Because Parliament has provided for that and has excluded the generalised discretion, which would otherwise arise. But my headline point, my Lord, is that that Section 21 provides the answer to all of this.
Yeah.
But I'm taking up the challenge that, well, where does it get you? Where does Section 21 get you on the facts? And I'm saying that the Secretary of State can't have two inconsistent positions. But my Lord, my skeleton deals with, if we can go to 552, page 85, letter D. Just below C. All this at a time when Parliament has expressed its will that there should be a scheme based on tortious measure of damages. And here, of course, I substitute in the Swiss. Such will being expressed in a statute which Parliament has neither repealed nor been invited to repeal. It would be most surprising, and this is the point of general principle, it would be most surprising if at the present day prerogative powers could be validly exercised by the executive so as to frustrate the will of Parliament expressed in a statute. And further down, relying on the De Keyser case, the prerogative powers of the Crown remain in existence to the extent that Parliament has not expressly or by implication extinguished them. If Parliament has conferred on the executive statutory powers to do a particular act, that act can only thereafter be done under the statutory powers so conferred. Any pre-existing prerogative power to do the same is pro tanto excluded. And the point, the simple and short point I make is that Parliament has specifically decided the prerogative power didn't do the job and has decided to exclude it and has replaced it with the statutory scheme. And the Secretary of State is therefore has to act within that scheme and not outside it. I've given up further quotes in the skeleton, which I don't think I need to go to.
Yep.
The next point is, well, what's to stop her having, on the one hand, a document that says, I will give 300 million, and a decision outside the document saying something else? And for this, I rely on the Great Portland Estates case, which is in the bundle that have...
Sorry to interrupt, Mr. Holgate, just to go back to the FBU case.
Yes, of course, apologies.
Your case is a fortiori the FBU case, because in the FBU case, the statutory scheme existed but had not been brought into force.
Yes.
Whereas here, you've got the statutory scheme.
Exactly. Yeah.
So it's completely inconsistent with any remaining prerogative power to do something in the more general area.
Yes, that's my headline point is that Section 21 is completely inconsistent with the remaining unconstrained discretion. That is my case.
Yeah.
But even if that were wrong, the question then becomes, well, if the section says you've got to have these policies in your SWIS, your objectives and your resources in the SWIS, can you have something outside that? And that's the Great Portland Estate case, which admittedly is in a completely different context, but again has points of general principle in my respectful submission. This is at page 31 of the authorities bundle. And this was a case where Westminster City Council had to adopt a local plan, development plan, and it had to decide what to do about office development, because there were demands for office development, and it wanted to restrict office development outside what's called the central activities zone of London. And if we read from the head note at paragraph E, in relation to office development, the City Council in paragraphs 1021 to 1023 of the plan drew a distinction between the central activities zone, in which office development was to be encouraged, and the rest of the city, where planning permission would not be granted, save in exceptional circumstances which weren't outlined in the plan, but was said to be subject of non-statutory guidance. And if we go down to the last 4 lines of this page, the applicants applied to quash 1021 to 1023 on the grounds that the City Council's comment was not an adequate statement of their reasons for rejecting it, and that by relying upon non-statutory guidelines to indicate what would constitute exceptional circumstances, the City Council had failed to comply with the requirements of Schedule 4, that the plan must contain the proposals. This is a case where you have to have a plan. Schedule 4 tells you it's to contain your proposals, and the question was, can you have something outside that plan? And the answer at below letter E on page 32 is no. The adoption by a local planning authority of non-statutory guidelines for development constituted a failure to comply with Schedule 4, and accordingly the order of those paragraphs of the plan should be quashed. And we can see Schedule 4, the words of Schedule 4 at page 36, 36F. I think I've adequately explained that. And the reasoning of the court is from page 43H onwards. And it's at letter D. What is the position, if it can be shown, as in this case, that the reference to exceptional or special circumstances is a cover for policies excluded from the plan? I'm not suggesting for 1 second this is cover for anything. The decision here is a cover for anything. But what is the position if you've got something outside the plan which should be in the plan? And the answer is the statute requires that a local plan shall formulate in such detail as the council thinks appropriate their proposals. If a local planning authority has proposals of policy for the development and use of land in its area which it chooses to exclude from the plan, it is in my judgment failing in its statutory duty. And then at just below F, it was the duty of the council to formulate in the plan its development and land use proposals. It deliberately omitted some. And my lord, the point I take from this is that once the Secretary of State has a intention to change the resources to be made available, she needs to do it in the statutory framework, because that's where the objectives and the resources are set out. Well, so that deals with the legal consequences of the correct interpretation of the legislation. And I now turn to the facts, if that's convenient.
Of course.
And I do this again from paragraph 50, and I can do it at quite some pace. I don't think there's much...
Paragraph 50 of your skeleton.
My skeleton, yes.
Yeah, thank you.
If we... the first point is, and we can get this from Miss Matthews' witness statement at paragraph 22, I think. Yes. In October 21, a spending review identified 710 million that would be provided by way of dedicated funding for active travel in the 3-year period ending March 25.
Sorry, which paragraph of her statement?
22 at page 36.
Thank you. Yep.
You see 4 lines down, the outcome of SR21 was published in the autumn of 21 and confirmed that a total of 710 million from dedicated funding would be made available for active travel over the following 3 years. So would be made available. That's the same as the statutory words. And we can see, indeed, if we go to paragraph 35, you can see how that's made up and it feeds directly into the £200 million cut. In the table at table 1, on page 38, you see the capital element of that is 460 million, and the revenue element 250 million, and we're concerned with the 23, 24 and 24, 25, 150 millions there. Those two were in the spending review, and they were then included in the SWIS at a totaling 300 million, and that's the figure. Those 300 million then came down to 100 million.
So instead of 150 each year, it went down to 50.
50, yes.
Yeah. Thank you.
Well, I mean, at page, just to rejoin the numbers up, it may not make a big difference. If you've got the supplementary bundle, page 44, there is the revised table, isn't it?
Yes.
Following the WMS, and it's 54 and 54.
54 and 54, yes.
Yeah.
I think
and the revenue column is adjusted as well.
Yes.
Yeah.
My Lord, I think I made it clear in one of the footnotes that the precise figure doesn't quite matter.
No.
The point. And I hope that's a fair way of dealing with it, because there is a dispute as to what the outturn figures actually are. Whether it's 200 million or 179 million. I think.
Your case is that the statutory procedure wasn't followed, and whether it was 200 million or 192 million is either here nor there.
That's right. So the SWIS was then published on the 6th of July 22, and this is obviously, well, all will have seen this. If we can go to the supplementary bundle page 3, and if I can just skip through briefly. And I'm not going to make jury points because the court won't welcome those. But at page...
That's a classic introduction to making one.
No,
so resist it.
I'm resisting the temptation to make one. If we can look at page 5,
Yeah.
just in the middle of page 5, there's a paragraph starting enabling more walking. But it's the next sentence. Working with local and combined authorities, we are delivering hundreds of miles of high-quality cycling routes, improved crossings, widening pavements.
Yeah.
So basically, it's all about local authorities delivering, the government providing, and the local authorities delivering. That's my point I was trying to make earlier. And then if you go through, you see the strategy, which sets the resources at page 6, sets the resources for the period April 21 to 25, and then importantly you get the objectives at the bottom of page 7.
Yep.
And then over the page you get the investment principles, and again just to show how Active Travel England fits in, again just between halfway down the page, the strategic investment principles, below will guide how Active Travel England, the DFT and government more widely invests dedicated and ring-fenced funds. So these are setting out the principles that the ATE will use when it decides who to give the money to through the bidding process. And then if we go on to section 2, which is at page 11, which is the financial resources performance monitoring and governance, and a correct statement of section 21 at the top. And then just towards the bottom, the main sources, we see dedicated DFT funding for active travel, then wider DFT programs, so not dedicated, and then other central government funding which delivers active travel infrastructure as part of something else. And we'll see how that works out in a moment. So the dedicated funding is then set out, and it's obviously I make the submission that that's a separate head. It's identified as a separate head, and it's this head that is the subject of the challenge. And then we see that the DFT delivers a range of capital and revenue funded programs as part of the 2 billion active travel, and we see those listed. So national cycle network, local authority capability, that's delivery of small schemes on a local authority area basis, behavioural change, Active Travel England and its role, e-cycle support, and then Mini Holland active travel prescription pilots, which I'm not sure I can help on what that is about. And then we see that the 2 billion of funding for active travel also includes a proportion of the city region sustainable transport settlements, which is included in head 1. Then we see head 2, which is the wider programmes, where DFT funds a range of capital programmes which deliver walking and cycling beyond dedicated funding. So those will be things such as highway schemes that have got cycleways alongside them, or roundabouts that have got pedestrian crossings added to them. And those are counted under the wider DFT programmes. And then we get the third heading is other central government funding, and this is areas such as levelling up funding, future high streets fund and towns fund. So this would be, for example, where money was being spent to spruce up a high street, the pavements and the crossings and the junctions might be improved as well as part of that, but it's not a ring-fenced part of that sum. It's just, and we see those different heads then set out in table 1, with the active travel revenue and capital funds being the fixed sum, the dedicated ring-fenced sum, and the 1298 changed to 1073 because of the double counting. That's the and within that 1073 is the 700. Is the 300 million that we're talking about here. You see that whilst we're in the table, if you look at the wider DFT programs, it's got a footnote, and if you go to footnote 8 over the page, it includes national highways designated funds and estimates of the proportion spent on active travel from the CRSTS funds. So expressly an estimate, because it's an estimate of the proportion of the dedicated pots.
When you say ring fence, does that mean can only be spent? They're dedicated. Dedicated. It's another word for dedicated.
Dedicated, yes.
Not must be spent.
Not must be spent. Dedicated for. Must be made available for. Or
can only be made available for.
It is identified, going back to section 21.1, is provided, dedicated, these are dedicated funds provided for the purpose. There are other non-dedicated funds that also serve the purpose, but these are the dedicated part of it.
And the non-dedicated funds, whether they're Department of Transport or other government departments, satisfy the resource definition in section 21, do they?
I'm not challenging lines 2 and 3.
But they qualify as making resources available.
Well, the government's position under it is that they are part of the pack of resources. In a different case, if there was not dedicated funding and there was simply a reliance on some other undedicated pots and the hope that some proportion of those would be spent on active travel, there would be a different judicial review. There would be a judicial review of that, of course, because the principal pot, the fundamental pot, is the headline, the dedicated funding, because it's specifically identified for this purpose.
But where there is dedicated funding, is it legally permissible to have non-dedicated funding of that nature and take that into account as part of the strategy? I accept that if there's bona fide projections of what will be spent or what will be made available, and that you can't be precise because it's in the nature of the beast. It depends on bidding, for example.
This bit wouldn't depend on bidding. This would depend on the decisions of others about how they deliver a highways scheme and what precise proportion of that they spend on a zebra crossing, for example. So as long as it's a bona fide projection based on evidence, then yes, I accept it can go into the pot. But it's not just an estimate out of the, as we'll see in a moment, it's not just an estimate that's pulled out of thin air. I'll come to that in a second.
And when that scheme, suppose doing up a high street in Town X, they were intending to put in a zebra crossing, and you can count that as encouraging walking, if not cycling, and they decide to drop it, and therefore 100,000 falls out of account. Is that a variation that you need to go through section 21, 5 and 6 through?
No, because the Secretary of State is making available the funds. She's making them available, and what actually happens then further down the line on an individual project basis, inevitably there will be the vagaries of time and of contractual arrangements and of the difficulties in actual delivery. That's a delivery issue rather than a resource allocation issue. And it's for further down the pyramid. As I hope I've shown, my lord, the headline position is the provision of the funding, and then further down we get the allocation to specific schemes. And as long as the bona fide projection at the outset as to what is to be provided based on, I'll come to the estimating process in a second, but as long as there's bona fide projections, and I don't say that there's an objection in principle to them being included.
But if I've grasped what you're saying, projections may change over time as circumstances change within those certainly the third line, and that is not a variation as such. But if, on the other hand, you're in the first line, and it's the funds to be made available by the department itself on dedicated schemes, you say changing that is a variation.
Yeah,
Have I grasped the distinction?
Yes, that is definitely a variation.
Yeah.
If the projection, if you cut all the other if you cut levelling up fund to nil, and you cut future high street funds to nil and towns fund, and you get rid of the CRSTS funding and so on, then you can't have a bona fide projection that you're going to be spending X, Y, and Z from that pot, and therefore that would also require a review or a revision, a statutory revision.
But that's not a revised estimation. It's simply deleting the head of funding.
Well, there would still be heads of funding under that, but it would loop. For example, if one looks at other central government funding in line 3, if say the future high streets fund disappeared, then your projection as to what sum would be spent from that on active travel might have to change. If there wasn't some countervailing uplift under the levelling up fund, for example. But my point is this: my fundamental point is that the first line is fixed, and if we go to supplementary bundle page 12, these are the words that my own friend focuses on and the judge focused on under the heading Total Government Funding for Active Travel. Table 1 provides an estimate of the total financial resources across government that may be invested in active travel over the 4-year period. And I make some obvious points. First of all, the estimate it has to be an estimate because for lines 2 and 3, it's projected. And we know it's an estimate from the footnotes. Secondly, this is about the total. It's not about line 1. It's not only about line 1. Thirdly, it's across government, so it's including and referring to pots over which the Secretary of State has no direct control. But the next sentence is important too. Many of the decisions on the allocation of these funds will be made by the relevant local body in line with local priorities, while ATE will ensure that relevant quality standards are met. And the short point there is that it necessarily follows that they are by definition projections. They can't be fixed sums. It's in the nature of the subject matter. And that's then explained in the next 2 paragraphs. The projected investment has been calculated using a range of evidence and data sources. This includes funding allocations previously announced, successful funding proposals from local bodies, previous research, historical trends, and an assessment of the proportion of investment into active travel projects and programmes from wider government funds. So that's all about the process of working out how to project. So that's a bona fide projection. Using the best evidence you can, what do we project will be the resources made available under the lines 2 and 3.
And so you say that paragraph certainly applies to lines 2 and 3?
Certainly applies to lines 2 and 3.
Just coming back for a moment to the dedicated funding, that's not project specific.
Not project specific.
So to some extent, does that depend upon bids being assessed on their merits?
Not the Secretary of State's decision to make the funds available to ATE.
That was the next question I was going to come to. But there is a pot of money.
Yes.
Assume it stays constant as being available. Nonetheless, the spending of that money will depend upon individual projects being assessed by ATE.
Yeah.
And that's why we see the expression value for money, high value for money, presumably in relation to some of the dedicated spend.
Yes, because the ATE's job is to make sure it spends it on value for money projects with a high BCA.
They're competing bids from different parts of the country.
Absolutely.
But you're distinguishing that situation, which insofar as it fluctuates, is not I think you're saying not a relevant variation any more than variations in estimates under 2 and 3, lines 2 and 3. You're distinguishing that from a headline decision to reduce the pot.
Yes, exactly. That's exactly my point. That the headline decision to reduce the pot is conceptually distinct from how the money is actually spent.
Allocated between competing projects.
And whether those projects are precisely on time, a bit late, whether they get the spades in the ground, whether they fail and the money goes back into the pot. I mean, of course, those sorts of things can't be the subject of a judicial review here, and that isn't the subject matter of this challenge. Of course, there's going to be vagaries in actual delivery, but this is a resource allocation question, not at the high level, at the top of the pyramid, before one gets down to the more detailed position. But, my Lord, the document also, on page 12, also makes reference to previous approaches to estimating the financial resources, and it refers across to SWIS 1, which is at page 80 of the bundle, of the supplementary bundle.
80.
80, yes.
Thank you.
And if we go to that, please, sorry, I should have said page 78. We can see the same framework in SWIS 1. At 78, you get the dedicated funds being set out. Then at page 80, you get the local transport programmes.
Actually, there you get a nice photograph showing you what a mini Holland looks like.
You do. Yes.
Sorry.
And then you also get local government programmes, and there's an important sentence here. Therefore, whilst government has a duty to set objectives and financial resources, this is at page 80. Whilst the government has a duty to set objectives and financial resources, which is at the top of the pyramid, if I can put it like that, increasingly the powers and levers necessary to deliver change will be held elsewhere. So actual delivery is elsewhere, but the objectives and financial resources are at a high level. And then we get the government programme over the page, government programmes where the schemes help directly or indirectly towards active travel provision. And we see again at page 88, still a guide to the amount that may be invested. But at the same point, many of the decisions on allocation of these funds will be made locally, in line with the government's devolution and localism agenda. So it's basically saying we'll give them the wherewithal, but how it then transpires on the ground is a separate question later on. And then the same point, and the SWIS 2 also refers to the 2020 report to Parliament, but I don't think I need to pick up anything from that. So I was going through the facts. So we have SWIS 2, and I say line 1 is not an estimate; it's a dedicated sum, and in my respectful submission, it's a contradiction in terms to have a dedicated capital fund in a fixed sum and to describe it as an estimate. The next stage in the chronology is my paragraph D. In November 22, the autumn statement made clear the need for significant reductions in public expenditure. And Miss Matthews explains how difficult that can be for a major projects organisation like the DFT capital budgets at 27 and following. For things like High Speed 2, you can't suddenly pull the plug, or for major highway schemes. Which explains that for projects already in delivery, it's difficult to stop, and we don't have any dispute with that. But at 31, she says, whilst the active travel dedicated funding had been agreed, but at that stage had not been contractually or otherwise committed, meaning that it could be reduced more easily than some other DFT programmes. And my point is that Parliament, in enacting Section 21, was trying to prevent it being so easy. It was trying to make it a difficult choice that had to go through the process to make sure that the benefits, the objectives and the resources were two sides of the same coin. The Secretary of State then carried out a review of all expenditure heads, including active travel dedicated funding, and we can see that summarised in Miss Matthews 27 to 42. And at 37, we see that at one point a 13% reduction was being considered, and that went through some deep dive slideshows in December 22. And the
which paragraph?
Sorry, that was...
is that 38?
37 at page 38.
Yes, 37. It's picked up in 38.
So this was a 13% reduction, and in a deep dive, and then the consequences of that in terms of what it would mean for 44 local transport authorities is dealt with in 38, cutting 50% of their funding. And then further figures were discussed, and then at 40, ministers were presented with 3 staggered options for savings from the local transport budget, which is a much wider budget than just active travel, giving reductions of 2%, 10% and 20%. Only the option of 20% included a reduction including the reduction in active travel funding. So lots of options being looked at, 13%, to 10% without any cuts to active travel funding. And then at 42, the second scenario was a 100% reduction in dedicated active travel funding.
Is paragraph 39 relevant to discharge of the 21.6 duty, if you're making a variation? because ministers were reminded of the public commitments to.
But yes.
Yeah.
But I don't understand it to be said that the statutory processes were ever followed through. And so they were being, at this point, the minister was, this is in December and February, and the minister was being reminded about that, quite right. And he would, if this had stayed with the minister, no doubt that his officials would have told him that Section 21 needed to be complied with. But we'll see later on that was bypassed. And my Lord, the upshot of all of those deep dives into the figures on active travel is that 45. In preparing this ministerial statement, following the deep dive discussions, it was initially thought that it would not include active travel and would solely outline reductions in other larger departmental spending programmes. So that was the position that when the Secretary of State had reached. And we need at this stage to have a decision document, the ministerial briefing, open at the same time at page 231 of the document. At 233.
233 of the supplementary.
Of the core bundle.
Yeah.
Core bundle. It's a redacted Annex A savings table.
Yeah.
This is the ministerial submission. And so the Secretary of State agreed with the Chief Secretary to the Treasury following the capital departmental expenditure limit bilateral on the 24th of January. Areas of spending would be managed. And if under the table there, you can see agreed with number 10, HMT and DFT. So the Treasury, number 10 and DFT agreed to a package of savings. As part of this process, HMT and number 10 accepted several of the savings options put forward by the departments. That's that part of the table. They have also confirmed additional savings to offset the remaining pressure. There are a small, and those are in the table at the bottom. You can see additional options agreed by number 10 and the Treasury. And you can see the contrast in the wording. Additional options agreed by number 10 and the Treasury, and then agreed with number 10, the Treasury and the DFT at the top.
And this was 24th of January.
Well, that was when the bilateral... No,
24th of January, which year?
23, that would have been.
Thank you.
So the bilateral had agreed the top of the table,
yeah,
or had led to the agreement at the top of the table. But then in the days, as we see from Miss Matthews' witness statement, paragraph 45, in the days immediately before the WMS was made, it was felt that funding reductions were still insufficient, and that's felt by the Treasury and the number 10. It was therefore suggested, and indeed it was required, that the active travel reductions were included in the statement. And we can see that because we see from page 233 that they were required by the Treasury and number 10. And we can see the £200 million over the page at page 234.
Yep.
And
what does pending next spending review mean?
Pending, it means there will be a spending review in 2020. 26/7.
So it was reduced or it wasn't?
No, it was reduced. It was reduced with effect from then for the next 2 years within that spending review period, and within the Swiss.
So what does then?
I'm sorry, am I missing one?
So that's just future years is pending.
Yes. Yes. If you go
To the top, it's just the future years.
Yes.
Yeah.
So if you can see 23, 24, 24, 25.
Yeah.
And so you can see the 100 million in each there.
So it is reduced, and the pending next spending review is for the future years rather than these years.
Yes, and doesn't help.
Well, they would relate to years in the next Swiss period.
The next Swiss period, which we've now told the next Swiss will follow the spending review that's awaited. So the position was that the Secretary of State had decided not to make cuts to active travel, therefore didn't need to go through the review process because there wasn't anything to review, or the revision process. And at the last minute, decision was taken that other savings were required. And that explains, or at least provides a possible explanation, we haven't got an explanation, but a possible explanation as to why nobody realised the implications of that for the need to go through the Swiss process. And so that may explain why the requirement to do the variation process got missed. But what happened, and what we see here, is exactly that which Section 21 is designed to avoid. It's a last-minute, ad hoc, piecemeal decision contrary to the Swiss. And it's being done under what's assumed to be a generalised discretion which Parliament had got rid of. Now, it might well be said, it isn't said, and there's no evidence to this effect, that the urgent national need meant the Secretary of State had no choice. I've got a number of answers to that. First of all, it's not a legal answer.
I suppose it might engage Section 31(2)(a) depending on what type of relief you were seeking, but if it's a declaration only, no, that happily goes.
And 31(2)(a) isn't raised.
No.
And the Secretary of State, who's under a duty to consult and to take into account various matters, can't then look back and say, right, I have to bypass the statutory scheme. But anyway, it's not raised, and so I can't address it. But in any event, if the Treasury had got on the phone and said we need to make further savings, she could have said, and she had to, in my submission, say, we are going to consider making savings to active travel through a revision of the Swiss. And we will consult on it, and we will consider that, and we'll consider the implications for the objectives in due course.
Well, looking from a practical perspective, I mean, this was proposing to cut a budget of 150 million for 23-24 to 50 million.
Yes.
This is a document in March 2023.
Yes.
The financial year is about to start in April.
Yes.
In one sense, it's imminent, but there's still 50 million in the kitty. So you might say, well, there's enough time to consult whilst you're spending the 50 million.
That was going to be my next point.
Sorry.
That the period 23-24 it allows for tranches of money to be given to ATE, to Active Travel England. And we know that one was given in February 23, 200 million. And so there wasn't any urgency as to deciding the amount of money to be given to ATE in the next tranche, whenever that was going to be. And in any event, we've had 6 months of this process since the Chancellor's autumn statement, with the position being discussed at the highest level on the 24th of January. And then suddenly this rush. And so in my respectful submission, the Secretary of State could have said, we recognise that there is still funding pressure on our capital budgets, and we are going to have to consult on potentially changing the active travel dedicated funds. But she didn't do that, and she jumped straight to the end point without going through the statutory process. And I should say that even thereafter, she didn't come back, even after this claim was issued, and even after the pre-action correspondence, she didn't go back and go through the process to decide whether that 200 million should be reinstated or could be reinstated, or whether some other revision should be made to the active travel budget. Now, I'm not going to make my learned friend's submissions for him, obviously, but the headline point in response to his approach and to the judgment is that it appears to depend on the continuing existence of a discretion outside the statutory framework. And if my lords could take up, and my lady could take up my learned friend skeleton, for example, 31 and 33. Halfway down 31, public law controls, so not the statute, public law controls will generally require the respondent to act in accordance with her own policies and strategies. However, it follows a fortiori from Holgate J's remarks that Section 21 does not deprive the Secretary of State of the power or discretion to make decisions about funding of cycling and walking other than through the Section 21 mechanism. And I say that's where the Secretary of State submission just goes wrong, for the reasons I've been through, that it's to be within the Section 21 mechanism and not out with it.
So is TAN wrong on that?
No.
Do you actually get that point from TAN?
No, because TAN doesn't say that. TAN talks about variations, but that's within the variation provisions. That's paragraph 126 of TAN. And then right at the end of 33, for example, the Secretary of State's decision to reduce AT funding was not inconsistent with the Section 21 duty to set an investment strategy, and Section 21 cannot be read as curtailing the Secretary of State's power to make such decisions. And in my respectful submission, that's exactly the point of what it must be read as doing. Now, my Lord, the judgment made a number of further points against my submissions, and perhaps if I could ask the Court to turn up the judgment now at core bundle page 51.
Thank you.
And the Court will see that the various submissions of the parties are set out in the previous pages. We see in 58, perhaps I can just run through this and say why I say, explain why I say each bit is wrong or not relevant. First, a strategy for investing in cycling and walking is not the same as a series of projects or programme of works. We agree, but that point goes nowhere. This is about the high-level strategy, not the site-specific decisions. TAN accepts, the second and third lines of the original SWIS are not fixed. The first line, stating funding direct from DFT, therefore should not, in principle, need to be a fixed amount.
You said that's a non sequitur.
Non sequitur, and in any event, it is fixed. It says it's fixed in the document. I think the most natural reading of section 21.3 is intended to be made available, rather than which must be made available as a minimum. Now, in my respectful submission, he must be saying intended to be made available at the date the SWIS is set, because otherwise, even on the 9th of March 23, the Secretary of State can't say she intends to make available the figure in the SWIS because she's told us she doesn't intend to make it available. But in any event, he goes on to say the latter interpretation would condemn an underspend, but not an overspend. And it is correct that there was an overspend in the SWIS 1 period, but I've tried to deal with this in my skeleton apologies. At paragraph 54. And the short point is that if there's an overspend, the Secretary of State will have complied with her obligation, with her requirements to make available the resources better.
She'll have overcomplied.
She's overcomplied. Now, whether or not that's within the power is a separate matter for a different day.
And who's going to challenge it?
Nobody's going to challenge it. And in my respectful submission, it doesn't assist.
aren't you making a slightly more fundamental point that outturn is a confusion of thought here? I mean, you might overspend or underspend.
Yes.
Either way, your point is, have you made the funds available?
Yes.
I mean, it may be that not sufficient projects come forward of sufficient merit
Yes.
to justify spending the money.
Absolutely. That's the headline point. But I need to be fair to my learned friend. The overspend in Swiss 1 was very dramatic.
Well, it may be, but whether it's dramatic or minor, it's a different concept.
It wasn't just because there'd been too many good projects. It was because the government made a decision to pump more money in under, I think it was called gear change.
And they didn't go through the variation procedure.
They didn't go through the variation procedure.
And perhaps they should have done.
Perhaps they should have done, and they might have been able to change the objectives as well. They might have
It's
been able
now
to up the
too late
objectives.
to get into that.
Yeah. That wasn't subject to any challenge at the time, as far as I'm aware.
But the question isn't even whether you've made the funds available, it's whether you've specified the funds
Yes.
that you make available.
Yeah. Now, and I deal also with the projections versus outturns at paragraph 53, which is my Lord Justice Holgate's point, I think. And this is my spades in the ground and projects being good enough and all that sort of issue. That's a delivery issue, not the headline resource allocation issue. Now, Miss Matthews very fairly talks about the scope for catching up later, and indeed, if we go to the ministerial statement itself,
So we're back where?
sorry, back to page 229
In the supplementary.
in the core bundle. Just at the end of the paragraph, there's only the paragraph on active travel is we remain committed, and it took a bit of work to work out what was actually happening here, because it doesn't say we're cutting 200 million or 100.
Well, I was going to ask that question. Are you on 236 now?
229?
Oh,
The penultimate paragraph.
Well, it's the same document, my lord. It's just it's a different version of the same.
sorry, your page...
229.
I beg your pardon, sorry.
But it's the same paragraph.
Yes,
I think.
thank you. I mean, just as a matter of fact, the reduction in the first line of Table 1, dedicated spending by 100 million, is that actually announced in the written ministerial statement?
No, it took a lot of time for us to work out what had happened. Indeed, there's in our original.
But if you have a SIS, one of the things you're supposed to do under the statute is to publish it.
Well, yes, and that's our point. They had to go through a revision and publish it. But
this is something you say should be treated as a variation to the SIS, that you say the procedure hasn't been followed, but there hasn't actually been a publication of the change.
There hasn't been a publication of the change either. And indeed, as we said in I think it's our statements of facts and grounds. I'll be corrected. Yes, it's our statement of facts and grounds, core bundle page 203. To cut quite a long story short, Tan was trying to work out what the statement meant, and we got a wide range of MPs and peers have asked parliamentary questions to seek to understand precisely the impact of the decision. This is paragraph 15, I should have said. But the answers provided have not given the necessary clarity. And then we go to the reduction in funding, and my clients and the legal team had to try to interpret what was going on, and we looked at various permutations to try to work out what the decision actually meant. Then Miss Matthews put us right in her witness statement when permission was granted for the JR.
Are you saying that the explanation emerges through these proceedings?
The explanation, the fact of the extent of the cut emerges through these proceedings. The parliamentary answers, the grounds say that peers and MPs were asked to ask questions, they did, and they didn't get any clarity. And we did get clarity, as I've said gratefully, from Miss Matthews' witness statement.
Under the sort of relevant duties. So we were looking at 229.
I'm jumping around too much. If we look at 229, we can see at the bottom of the relevant paragraph, it says, we will review these levels as soon as practically possible. and Miss Matthews correctly says that it was hoped.
Sorry, where does, oh right, the final sentence.
Yes,
Yeah.
yes. Yes, for example, paragraph 64 onwards, a page, supplementary bundle, page 44, paragraph 64, Ms Matthews says, the department remains committed to reviewing the active travel capital funding as soon as possible as part of its normal budgetary processes, and the actual size of the reduction will therefore depend on whether it's able to identify further funding for active travel over the course of 23, 24 and 24, 25. So that was a witness statement in November 23, and so there isn't a further witness statement saying that further funding has been found. No doubt we would have had one if there was. But even if the 200 million subsequently reduced, this is a challenge to the decision at the date it was made. And there's no evidence that either the 200 million has been subsequently reduced or that it was intended to be offset by increases elsewhere.
Well, your point is that any variation needs to follow the statutory process.
Yeah. So there are a number of matters dealt with in the judgment on that page. I mean, that page is basically the totality of the analysis. I'm confident that I've addressed all of the ones that go to the overall logic, and I say that on each bit, the judge erred. But going back to my skeleton, at paragraph 35, once the court has read the judgment, paragraph 58 to 63 again, I say it's striking that nowhere does the Secretary of State or the judge engage with the essential features of Section 21, as set out above, engage with how Tan's interpretation embodied, reflected and secured the statutory purpose, articulate how the Secretary of State's interpretation was consistent with the statutory purpose, rather than emasculating Section 21 and restoring the general funding discretion, or engage with the import of the key words. And after having carefully considered my own friend skeleton, I stick with those submissions. I think that brings me to the end of my submission. Can I just check those behind me?
Of course, yes.
It's been confirmed that strategy isn't defined in the Act, so...
No, well, thank you very much indeed, Mr Bishop. Good, thank you, Mr Borsick. Yes, Mr Flanagan.
Thank you, my Lord. The structure of my submissions, I'm going to first deal with the allegation of inconsistency with Section 21, which is interpretation of statute, and then secondly, the estimate point, which in my submission turns on the interpretation of the strategy itself. So starting with Section 21, some overarching points on interpretation. I say it's important that it requires the setting of an investment strategy. And those words and that terminology, I say, is important to the interpretation of the duty. So it's a strategy or plan for investing expressly, as opposed to being cast as a statement of mandatory spending commitments, which must be fulfilled and are irreversible unless the strategy is formally varied. In my submission, the appellant's case does amount to construing Section 21 as in creating a statement of mandatory spending commitments in the strategy, which can't be departed from unless the strategy is varied. Second point is that I said there are clearly mandatory elements within section 21, but it's important to identify precisely what those mandatory elements are. The first is that there is an obligation to set a strategy. And you get that from the combination of subsection 1 and subsection 9. Secondly, and relevantly, there is an obligation for the strategy to specify certain things in subsection 3. So it has to specify the objectives to be achieved and the financial resources to be made available. But those are the principal elements, mandatory elements relevant to our case, and that does not extend to an obligation, once you've set the strategy, thereafter to abide by those spending commitments come what may.
Well, I think the point that's made is that there's an express process for varying the strategy. So the argument would be, yes, of course you can change the sums that are specified, but you need to go through the variation process.
Yes, obviously that is a fundamental plank of the learned friend's argument, but in my submission, the simple existence of a statutory variation mechanism, it doesn't follow from that unless the variation process is pursued, that the strategy is essentially a straitjacket.
Yeah, I think, as I understand it, the appellant's cases, you're quite right, those are mandatory things that you identified from section 21. But what I suspect Mr. Forsdick would add in is a mandatory variation procedure. So if you do want to change the funding that you've made available, fine, but just go through the variation procedure set out in the statute as well. And he would, I think, and I'm getting a nod, contends that's mandatory, and that is what seems to divide you. So your contention is that section 21, 5 and 6, that the provisions in relation to variation are not mandatory. Is that fair?
It goes back a stage in my submission to answer not directly, but it depends what you're varying. You have a strategy which specifies resources. A decision down the line, for reasons of financial stringency or other reasons, not to make all of those resources available or to change your approach, does not necessarily mean you're in breach of section 21.3. So it doesn't, and therefore does not, you're not obliged to vary. So yes, is the answer, I suppose, that section 5, subsection 5 and 6 are not mandatory provisions in that sense. But I also make the slightly separate point that the simple fact that the statute includes this variation provision that doesn't, obviously that's relevant to the construction of the duty to have a strategy, but it doesn't mean that unless you go through that variation procedure, the strategy is, there is no discretion to make less funds available for any particular reason.
This is what I'm struggling to understand.
Yeah, me too.
Let's say you have something which qualifies as a variation. Now, presumably there must be something which could qualify as a variation of the strategy. Is it your case that it's permissible, consistently with the statute, to do that in an extra statutory fashion? Or do you have to comply with the statute and go through the procedure, if it is genuinely a variation?
If there's a decision to vary the strategy, then the procedure needs to be followed.
Yeah, so the question then comes down to what is a variation?
Yes, it does.
Well, what could a variable? I mean, if you're changing something that you're required by subsection 3 to specify, why on earth isn't that a variation?
because the strategy remains in place, that you will have those total overall resources. You have not, arguably, subject to what the strategy says, met that strategy in one respect. It doesn't follow from that that you have decided to vary your strategy and therefore need to go through the variation procedure.
But you've announced a decision that instead of making £5 available for the purpose of achieving the objectives, you're only going to make £3 available. Is your submission that you're not required to go through the variation procedure if you do that?
Correct, unless there's a decision to vary the strategy. And there was no such decision in this case. There was a decision.
So it depends on whether the Secretary of State labels what he or she has done as I am varying the strategy. Is that it? How do you tell whether the duty to go through the variation procedure is triggered or not?
I say it's not simply a point of labelling. It's possible to have a strategy, but to consciously not be able to fulfill it in some respects, but still have that strategy in existence and not wish to vary it. There may well exist a tension as to what is happening and the strategy that you have in place, but that it doesn't follow from that you've implicitly somehow made a decision to vary the strategy.
I mean, the difficulty I have with that submission is that it's very difficult to see how one knows whether or not the Secretary of State is required to consult people about a proposed change to the strategy, because there's no touchstone for knowing when the duty to go through that process exists or doesn't exist.
It would depend, in my submission, on whether there is a decision, whether expressly or in substance, that is a variation. And in deciding whether there is such a decision, it shouldn't just depend on whether all the resources are going to be made available that have said are going to be made available. It needs to look at whether the Secretary of State has actually decided to vary.
Well, to vary in terms, or I think you were accepting, even if it's not said to be a variation in terms, if it is a variation in substance.
Yes.
Because otherwise it's a label or formalism. Is that correct?
To some extent, it can't be simply a matter of labelling. The substance is relevant, but the fact that, as I say, that a strategy is in place but not fully being achieved, that's the substance of that position. It doesn't follow from that there has been a decision to vary or there is a variation.
Well, it may be, I can see what you're saying then, in the sense that maybe it's not being fully achieved because schemes haven't come forward which merit public expenditure. But I think what Mr. Forsdick is saying is the difference between that, which to some extent central government has no control over, it depends upon people putting forward meritorious schemes, as opposed to government saying, we're actually, whatever the schemes that come forward, we're actually going to reduce the pot available for such schemes by £200 million.
I agree that there is a distinction between those two matters, but even in the second, the top line reduction, I think it was put in argument, it doesn't follow from that you've somehow abandoned, want to vary your strategy. You can still have your strategy in place, which was your statement of intent for that 5-year period or whatever it was at the beginning. But during that 5-year period, due to circumstances arising, you've decided that you're going to make some of that funding not available. But that doesn't mean you've implicitly or expressly varied your strategy. It's a specific isolated decision about one matter which is relevant to that strategy.
Here we're dealing with decision to reduce the available spend funds by 100 million per year in the last 2 years of the strategy. So there's actually no subsequent headroom for, within the time period of the strategy, to recover that or make up for that reduction.
Not in terms of the dedicated funding,
No,
but
no.
the total funding there certainly is, as was shown in the first strategy, where it estimated 1.5 billion and turned out to be over 3 billion.
Yeah.
And therefore, and that can't be assessed until after the end of the strategy properly.
But, okay, was there a revised projection for lines 2 and 3 showing that they were going to go up?
No, there is no projection as yet.
No.
As part of the reporting process, that will be undertaken.
Hmm.
But it is entirely possible, in my submission, based on the evidence of the first strategy, that lines 2 and 3 will have actually produced and gone up more than enough to account for any reduction in line 1. It's an unknown.
That's just speculation, isn't it?
But speculation based on the recent and quite compelling evidence from, or at least striking evidence from the first strategy.
And so your argument is that the possibility of it going up by that 200 million means that it must be wrong to analyse line 1 in the sort of binary way that you say the appellants are doing.
Absolutely.
Yeah.
And I also
Was this line of argument part of the decision making back in March 2023?
there's nothing. I can't point to anything that says it was. No. I'll come back to it when we're looking at the strategy itself. So I say it's relevant to how you construe the strategy, but just sticking with the statute for the moment. So I go on to say, after identifying the mandatory elements, and the effect of the appellant's argument is to turn what is an obligation to have a strategy into an obligation to not only have a strategy but deliver it and not depart from it during its term without the formal variation process that we've gone through. So those are two different types of obligation.
But I think Mr. Ford disavowed that argument. He's not saying there's such a wide duty. All he's saying is that there's a duty to specify the matters that are described in subsection 3, and then if you want to change the matters that you are required by subsection 3 to specify, you've got to have a consultation process and to vary the strategy. It's a pretty simple argument.
It is a simple argument, but when I say one looks at the detail of the section, it's not supported. So when I go on to looking at subsection 3 in particular, the strategy must specify the objective to be achieved and the resources to be made available. It must be, I think it is common ground that there's no obligation that the objectives have to be achieved.
No.
And if you follow that logic into 3b, that would mean there's similarly no obligation for the resources to be made available.
No, you've just got to specify them.
Which is, in my submission, what the strategy does.
Well, until you say, actually, we're going to change the strategy and not make these funds available, even though we said we would previously.
Yeah, so that would then come back to whether there's any suggestion that the strategy is being changed. I do rely on that. Section 3, the structure of it, in my submission, the obligation is to specify two things, no obligation expressly to deliver those two things. And if that's conceded in respect of objectives, I say it must follow for resources.
Well, it depends what you mean by deliver. A simple English word is spend. you're not obliged to spend the money, but you are obliged to say how much will be available for potential spend. That's the distinction, isn't it?
Obliged to say how much will be available.
Yes.
Which was what was done in the strategy. But the second stage is to say, well, there's an actually obligation to thereafter make them available for the duration of the strategy. And that is a more onerous obligation. And it's not right that you have to achieve the objectives, 21.3a. And if that's right, why, in terms of legal obligation, do you have to make the resources available? You simply have to specify, and there may be public law controls which affect decision making, but in terms of what the statute provides, that's the limit of it.
Well, coming back to 3A, the obligation is to specify at the outset of the strategy the objectives to be achieved during the strategy period.
Yes.
Now, you may not achieve all those objectives during the statutory period, but if you decide during that period to amend what those objectives to be achieved are, that's a variation, isn't it?
Potentially, yes. But taking that logic to 3B, if you had decided that you weren't going to make the resources available, you might therefore choose to vary the strategy. But that's not a decision that was taken. And the statutory duty, which is to have a strategy specifying those two things, remains complied with. I also make a broader point that, still on the statute, that the effect of the appellant's argument is that the Secretary of State no longer has power outside this framework, as in the setting of the strategy and the variation framework, to make any spending decisions which would reduce the resources specified in the second strategy. And that is a bold and, in my submission, unrealistic submission, which cannot have been there's no indication it was the intent of Section 21. It would be a very far-reaching legal constraint on Secretary of State decision-making.
But that's not the effect of Section 21. Section 21 doesn't stop the Secretary of State from changing the amount that's specified. All it requires the Secretary of State to do is to vary the strategy by consulting people. So you're tilting to windmill by making that point, aren't you?
But even to that extent, it's imposing a mandatory procedural hurdle in the way of...
Because Parliament's chosen to do that. I'm just finding it very difficult to understand how there's any way round what seems to me at the moment provisionally to be the clear language of Section 21. And it may be surprising, but that's what the words appear to say.
Yes, well, I say that the surprising nature of it, plus what I say that my submission on the detailed wording and what the mandatory element actually is, put those two together in my submission, and for those reasons I say that Learned Friend can't be right. And the surprising nature would extend to being able to get an order or declaration from the court, the effect of which would essentially be that the Secretary of State had to maintain, unless the formal variation procedure was gone through, have to maintain the level of resources and therefore divert resources from elsewhere, essentially. And that sort of constraint on ministerial decision-making in my submission would require clear words. And I say they're not. You don't find them in Section 21.
That would still leave the question, when would you come face to face with something which is a variation and does require these procedures to be gone through? If this is not it, what would be? by way of example.
There could be a radically different approach to delivery of active travel, which, in Wednesbury terms, the Secretary of State couldn't pursue without it being irrational because of the existing strategy. And in that situation, I accept that a challenge to that decision, unless it was taken through the Section 21 procedure, might be successful. But I go back to the fact that when there's no intent to vary the strategy, just because the decision taken produces even a tension between what is happening on the ground and what the strategy says, that doesn't force the Secretary of State to start a variation procedure.
So how do you tell whether there's an intent to vary?
It would come from the Secretary of State unless the facts are so obvious that there's no other conclusion that could be.
So if the Secretary of State says, well, I'm not intending to vary this strategy, but I am going to reduce the dedicated funding that I've specified in the published version of the strategy by £200 million, I don't intend that to be a variation. Would that mean that the variation procedure is not engaged?
If it was, provided it wasn't a simple matter of labelling to disguise what was actually going on, yes. And in my submission, you could have a scenario where the strategy was in place, the Secretary of State, for whatever reason, there was a period when it was recognised by the Secretary of State that the Secretary of State was not going to be able to comply with that strategy. Perhaps a short-term period, not lasting forever. With the hope that down the line the strategy would be, there would be compliance was achieved later. But the simple fact that it was recognised for a period there was going to be non-compliance would not, in my submission, oblige the Secretary of State to start up the variation procedure. Certainly that would be an option for the Secretary of State to do so, and depending on how long the period was going to be and other factors, the Secretary might well choose to adopt the variation procedure, but the statute doesn't require that. In my submission, the statute is satisfied by there being a strategy, and any failings to achieve or implement that strategy would be, the Secretary of State would be accountable to Parliament for that, expressly through the reporting procedure in 21.8, and also conceivably through public law controls on the basis that a strategy is such as this anyway is almost certainly likely to be a mandatory material consideration in any decision on funding, such that any significant decision I say that those points are important on the basis that also within my learned friend Skeleton, but he says that the Secretary of State's interpretation undermines the purpose or renders the section devoid of practical consequence. And the only way to avoid that is to interpret in the strict way that the learned friend suggests. I say that's not the case. And there are three reasons particularly. On the Secretary of State's interpretation, the duty still has substantial purpose and practical consequence. Firstly, it ensures that there is forward planning for active travel funding. It ensures, as the judge called it below, a structured and coherent approach. It might not be as strict and enforceable as it would be in my learned friend's interpretation, but it still provides for that. There has to be a strategy, it has to plan forward for a period of time, it adds structure and coherence. And I say that it's not the case that those matters can only be achieved by an absolute duty to keep the funding available unless you vary. So that's the first point why I say the duty still has consequence on my interpretation. The second is the point about public law controls that, as I've said, the strategy is going to be a mandatory material consideration in decisions on funding, in the sense that it would be Wednesbury unreasonable for the Secretary of State to reduce funding but not have regard to that strategy, not because of statutory obligation but because of Wednesbury. And for that reason also, the duty and the strategy are going to have practical effect, because it is going to provide a fetter of some sort. The learned friend says Secretary of State's approach is unfettered, but I say it's not. In real terms, that would provide a fetter. It would mean it has to be considered, which it was in this case.
Sorry, I'm just trying to keep up. Has to be considered when you're taking a decision to do what?
To reduce active travel funding in a way which is reduces it beyond the initially anticipated amounts set out in the strategy.
Well, if you're going to reduce the funding available as set out in the strategy by a certain amount, by definition you are taking into account the strategy. It's the amount which you're reducing. It's not really adding very much, is it? What's the fetter?
Well, on the basis that with the dedicated funding in this case and the 710 million, that's not only the effect of the duty is that's not only a figure in the internal accounting of and budgeting of the department, it's a figure which has made itself into a strategy, which is a published document which there's an expectation that will
but I mean, if that analysis is correct, no matter what the size of the reduction or the alteration of the funding made available through the strategy, you could simply say, I'm having regard to the strategy when I reduce that amount. And I've complied with the Wednesbury requirement to take into account a mandatory material consideration. But by that analysis, I'm entitled as a matter of law to say that's not a variation.
Yes, as a matter of law, you would be. But it might be, in theory at least, that the decision taken is so contrary and so incompatible with the strategy that unless careful regard is had to the strategy, the decision doesn't survive a challenge. Sorry, the decision doesn't survive a challenge. So there's the control of that sort, and then thirdly, there's the political accountability point. The fact, as I've said, that the section includes two provisions whereby there's political accountability to Parliament. Section 21(8), that you have to, from time to time, report before Parliament on progress, meeting objectives, and in subsection 9, if there's not a strategy in place, you have to explain yourself and set one as soon as possible. I accept that's obviously not a determinative consideration, but it does mean that the non-compliance with the duty has consequences, potentially. It's not an empty duty, because if you don't comply, you will be reporting that non-compliance to Parliament.
And which duty are you now talking about?
If you don't fulfil the objectives.
But you haven't got a duty. Section 21 doesn't impose a duty to fulfil objectives.
No, so shows my words badly.
No, well, that's why I was asking you what duty you're talking about.
Yes. So you wouldn't be reporting non-compliance with a duty. You'd be reporting the fact that you are not meeting objectives and explaining why.
Right.
Not meeting objectives and not providing the resources that you originally specified, I suppose.
Yes.
Now, is that a convenient time for you to have a break, or we can perfectly...
It is, thank you.
Good. And you all seem to be very much up to speed. Just as a guesstimate, and only a guesstimate, how long do you guess that you're likely to be?
Perhaps another half an hour.
That's fine. And then time for a reply. Yeah. Good. Well, thank you all very much indeed. We'll look forward to seeing you at 2 o'clock.